Key concept number 1, separate ownership from beneficial use and control. Nelson Rockefeller once said, "The secret to success is to own nothing but control everything." That pretty much sums up key concept number 1, separate ownership from beneficial use and control. It's pretty obvious that suing someone with no assets gets you nothing. That's why people with no assets don't get sued. If there's no money to be made, who's going to invest their time and effort in a futile lawsuit? Certainly not lawyers. That's the power of key concept number 1, to remove you from the direct ownership of your assets, but leave you with the beneficial use of those assets as well as control. How do you do that? Find out with key concept number 2, use a trust. Key concept number 2, use a trust. Famous Supreme Court Justice Oliver Wendell Holmes once said, "Put not your trust in money, but put your money in trust." A trust is a very special form of ownership, which has been used as far back as our English common law roots. A trust is formed when one person, called a settlor, places an asset with another person, called a trustee, who agrees to take care of that asset for yet another person, called a beneficiary. The trustee is required to follow the directions inside the trust about how and when the beneficiary has use, control, or even direct ownership of the trust assets. For generations, wealthy families have used trust to protect beneficiaries from squandering the assets, divorce, poor investing, bad decision making, and yes, even lawsuits. How can a trust do all this? Find out with key concept number 3, irrevocability. Key concept number 3, irrevocability. Author John Geddes said, "True love is an irrevocable act. You can only give away your heart once. After that, you give as much as you have left." Irrevocability is a pretty powerful concept. Basically, it means that once you set the path in motion, you cannot change your mind. This is like jumping off a bridge. You can't just climb back up. And it's irrevocability which allows a trust to withstand the attack of a fierce creditor. When the settlor makes a trust irrevocable, he or she fixes the terms and removes the power from even themselves to revoke or undo the trust. This means that once the assets are in there, they can only come out as determined by the terms of the trust itself. And it is here where we can add a very special kind of term, which can also protect trust assets from creditors. What is that term? Find out with key concept number 4, spendthrift provisions. Key concept number 4, spendthrift provisions. Indian actress Soundarya understood this concept well when she said, "Luckily, I have a brother who looks after my money because I'm a total spendthrift." Spendthrifts go through money like water. And when Daddy Warbucks is considering how to bequeath his estate to little orphan Annie, you can be sure he's going to add some provisions in there to protect her from herself. These are called spendthrift provisions. Spendthrift provisions put limits on how beneficiaries can access trust assets. They can be hard and fast rules like, "My son shall have no distributions until he makes it through graduate school." Or they can be flexible and discretionary, like, "The trustee may make distributions if the beneficiary proposes a solid investment." But one of the most powerful of all spendthrift provisions relate to the protection from creditors. When these provisions are used, creditors cannot reach trust assets, even while a beneficiary enjoys their use. And this is where it gets interesting for asset protection. So how can you set up a spendthrift trust for yourself, just like Daddy Warbucks did for little Annie? Find out with key concept number 5, self-settled trust. Key concept number 5, self-settled trust. Ralph Waldo Emerson said, "Self-trust is the first secret of success." If you aren't lucky enough to be inheriting your assets in a protected spendthrift trust already, then we have to come up with a way to do it for you. And to do that, we use key concept number 5, create a self-settled trust. A self-settled trust is a trust which you create for yourself, with yourself as your own beneficiary. Self-settled trusts have been used for generations. In fact, every revocable living trust, which is commonly used for estate planning, is a self-settled trust. But there's a catch. To get the full benefits of asset protection, you need to combine all of these first 5 key concepts. But in many places, it's not possible to self-settle a trust and make it irrevocable and include those all-powerful spendthrift provisions. To do this, we have to understand key concept number 6, jurisdiction. Key concept number 6, jurisdiction. Australian Prime Minister Tony Abbott said, "I am extremely unwilling that we should take upon ourselves to exercise a jurisdiction which the law does not vest in us." Jurisdiction may be one of the most powerful of all our key concepts. You know it from the detective movies, when the FBI and the local police fight over the jurisdiction of a murder case. What jurisdiction means for us here is that the laws and rules that govern both people and trusts are different from one jurisdiction to another. This means from one state to another and from one country to another. In fact, in most jurisdictions, it's not possible to combine an irrevocable, self-settled trust with spendthrift provisions. And even in the limited number of jurisdictions which do allow this, there are lots of differences which affect how safe your assets really are. So how would you get the most out of all these concepts? Find out in key concept number 7, the offshore edge. Key concept number 7, the offshore edge. NBA All-Star basketball player Eddie Jones said, "Home court changes everything. If you have home court, you're expected to win." Home court advantage means the fans, the energy, and even the refs are on our side. And when a team needs that edge, home court provides it. When it comes to asset protection, the most powerful home court in the world isn't actually anywhere near home. It's a small jurisdiction way off in the South Pacific called the Cook Islands. It was here that the very first piece of legislation was passed, which specifically allowed for the combination of an irrevocable, self-settled spendthrift trust. This was the birth of what has now become known as the Foreign Asset Protection Trust. Not only did the statute create the trust, but it created a statutory framework second to none in its effect on protecting those trust assets. In the Cooks, if you want to get into a trust, you have mountains to overcome. The Cook Islands are statutorily prohibited from recognizing any U.S. judgments or court orders. Also, if a plaintiff wants to file a case, he better be quick. The statute of limitations is short and final. If he is able to get a case filed in time, he now has to prove his case beyond a reasonable doubt, which is the murder standard and the highest possible burden of proof anywhere in the world. He can't use his U.S. lawyers. They aren't allowed to practice in the Cook Islands, and he's not going to be able to get a contingent fee attorney because contingent fees aren't allowed. And he'll have to get the checkbook out and pay for the costs of flying a judge in from New Zealand and all court expenses. The bottom line is that protecting your assets in a Cook Islands trust is arguably the best home court advantage anywhere in the world. So what else do you need to know before accessing this level of protection? Find out with key concept number 8, cost versus benefit. Key concept number 8, cost versus benefit. Canadian author Margaret Atwood said, "Nature is an expert in cost-benefit analysis. Every benefit has a cost. When it comes to utilizing a foreign asset protection trust, that cost comes in the form of expense, control, and compliance. The expense of maintaining a foreign asset protection trust can easily run between $4,000 and $10,000 or more per year. Control of that trust must be with the foreign trustee if you want that trust to work. And compliance with the IRS requires a foreign trust to file several forms each year. These include Form 3520, 3520A, the FinCEN 114, as well as a growing list of disclosures under the Foreign Account Tax Compliance Act. Fundamentally, none of these things create any extra tax, but they do require a full disclosure of trust assets and account balances each year. If you're defending your assets from an aggressive attack, these requirements are a small price to pay. But for many people, these costs tip the cost-benefit scale enough to pass on that gold-plated offshore protection. So, is there a way to avoid these foreign trust complications? Find out in key concept number 9, the domestic upside. Key concept number 9, the domestic upside. Greek philosopher Aristotle said, "It is the mark of an educated mind to be able to entertain a thought without accepting it." The domestic upside is all about capitalizing on the protections available to us in the U.S. We already have statutes and laws in virtually every state that provide some form of ownership that is designed to limit liability, like companies, partnerships, LLCs, and yes, in a few states, even the coveted Asset Protection Trust. Many of these statutes and the case law in some of the better states are very good and can provide a sufficient level of asset protection without the expense of going offshore. This works well to a certain degree, and these entities can even be combined with the power of an asset protection trust. When it comes to the Asset Protection Trust, we now have a third of the U.S. states which have passed domestic legislation allowing for the creation of a self-settled, spendthrift asset protection trust. The upside is that there are no foreign trust reporting requirements, and in general, it's simpler to maintain a domestic APT than a fully foreign APT. So if we can do all this domestically, why consider the offshore edge at all? Find out in key concept number 10, the domestic fatal flaw. Key concept number 10, the domestic fatal flaw. Supreme Court Justice Oliver Wendell Holmes said, "Even a dog distinguishes between being stumbled over and being kicked." So what is the fatal flaw of using a domestic-only asset protection plan? Consider this. A statute in one state may provide for complete protection, while a court in another state may not agree. And for better or worse, we are the United States, which means that we all must adhere to the U.S. Constitution. And that Constitution specifically states under Article 4, Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. So, no matter how good the laws in Nevada, Delaware, or Alaska are, no jurisdiction can simply ignore a judgment or a court order from another U.S. jurisdiction, or from the federal court system, which sits on top of state law. So while it may seem theoretically that we can get all the protection we need domestically, in reality, we have thousands of cases of judges, courts, and juries going off the rails, seemingly ignoring statutes, precedent, and other court rulings. Add to that an army of attorneys who literally make their living in what has become a $300 billion a year lawsuit industry, and it's pretty easy to feel kicked in a U.S. courtroom. In practice, the result is that we have a serious lack of predictability in virtually all U.S. courts. You can and should use the domestic tools which are appropriate, but if you're really serious about protecting your assets, you want to build a way out of the U.S. when push comes to shove. So, is it possible to get offshore protection with domestic simplicity? Find out in key concept number 11, the Bridge Trust. Key concept number 11, the Bridge Trust. Turkish playwright Mehmet İldan said, "The wisdom of bridges comes from the fact that they know both sides. Not happy with this side? Cross to the other." Bridges are the geniuses which make this possible. The power of this key concept is that it allows you to use the best of both the domestic and the offshore jurisdictions. The Bridge Trust is a very specific type of asset protection trust which is fully registered offshore with all the formalities. This anchors one side of the bridge. The trust is then constructed back into the United States to anchor the other side. This allows the trust to be treated for U.S. tax purposes as a fully domestic, simple grantor trust. The result is that your assets can stay in the U.S. under your control. There are also no U.S. tax compliance reports, no extra IRS forms, and no increased offshore costs. But if the assets of the trust are ever truly threatened, they can be driven across the bridge and the trust becomes a fully foreign Cook Islands Asset Protection Trust. The result is full offshore protection for your assets only when you need it. The rest of the time, you can continue to use, manage, control, and protect your assets the way you want. How exactly can you do that? Find out with key concept number 12, use a COP entity. Key concept number 12, use a COP entity. Famous American author Henry Miller said, "The legal system is often a mystery, and we, its priests, preside over rituals baffling to everyday citizens." Key concept number 12 highlights one of those mysteries, the COP entity. A truly solid asset protection plan will maximize all available legal protections on both sides of the bridge. This means that if you're a U.S. person, you want to arrange your assets inside the best domestic structures before you connect them to your bridge. Some of the most important of these are known as COP entities. This stands for Charging Order Protection Entities. You may be more familiar with these as limited liability companies and limited partnerships. LLCs and LPs differ radically from traditional corporations in the way that they legally define ownership. In a traditional company, the owner holds shares. These shares are seen by the courts as just another asset. And if you have a judgment creditor, then all the shares you hold are readily available to satisfy that creditor. Charging order protection entities define ownership in terms of membership or partnership. And just like a membership to an exclusive club, the COP entities can prescribe severe restrictions on who is allowed to become a member. In a well-drafted LLC or LP, you can exclude a creditor from ever becoming a member or a partner. The best a creditor can get is a charging order, which is a limited right to receive uncertain future distributions to which the real member would be entitled to. But under normal circumstances, a judge won't break up a COP entity or force any distributions. By arranging U.S.-based assets in appropriate charging order protection entities and then connecting those entities to the bridge trust, you have truly unlocked the power of asset protection's key concepts. But there is one catch. All of this planning must be done before you find yourself in a bind. Find out why with key concept number 13, fraudulent conveyance. Key concept number 13, fraudulent conveyance. Famous American poet Ogden Nash said, "Some debts are fun when you're acquiring them, but none are fun when you set about retiring them." Debt has become a standard feature of American life, and with debt has come a legal system designed to help creditors collect it. A primary feature of that system is key concept number 13, fraudulent conveyance. Fraudulent conveyance basically says any conveyance, which is a transfer of ownership, made with an intent to delay, hinder, or defraud a creditor may be undone. What this means is that if you intend to protect your assets by conveying them into an asset protection plan, you need to make that conveyance before you have a creditor issue. What key concept number 13 tells us is that when it comes to asset protection, you need to do your planning as soon as you have any assets to protect. So how much is that? Find out in key concept number 14, the target zone. Key concept number 14, the target zone. Canadian author Emily St. John Mandel said, "It's an awful thing to be the target." This is especially true when you're the target of a lawsuit. I've seen business owners and professionals break down completely, even just receiving the service of process and reading the complaint. The uncertainty caused by this can be nothing short of traumatic. And it doesn't stop there. Depositions and court appearances ratchet up the heat, and the fear is an orchestrated attack on your emotional well-being designed for one thing: to get you to pay them money to go away. This is called legal extortion. And sometimes the more off the wall and ridiculous the claim is, the better it works. Plaintiffs' attorneys have identified the profile of target who is most susceptible to the legal extortion racket. And it's not the super wealthy. They have lawyers, and lawsuits are often commonplace to them. The best possible target is the millionaire next door. These are professionals, business owners, and anyone who has accumulated between $1 and $5 million of net worth, who have worked hard to get it and who have never been sued or in serious litigation. The psychological attack on this person can be devastating. And even when the claim is covered by insurance, just the mere fact that there's a chance that something may exceed coverage, or somehow the coverage will fail, or that the claim leads to another, can cause extreme stress. Losing or even spending $500,000 in a lawsuit today is pretty easy. And when starting with just a few million, the impact is significant. In my experience, it's these people who benefit the most from establishing a solid asset protection plan. It reduces fear and creates a sense of security that you have a backup plan in the worst case scenario. This itself creates a much higher capacity to deal with any challenges and virtually always leads to a better final result. How can you make sure that you're ready? Find out in key concept number 15, education versus action. Key concept number 15, education versus action. English philosopher Herbert Spencer said, "The great aim of education is not knowledge, but action." Asset protection works best the longer it's been in place. Just like a fine wine, starting with a great plan and then letting it age is the real key to protecting your wealth. To begin, we recommend you take 4 steps. 1. Find an attorney you're comfortable with who uses a style you like. Style does matter, and using an attorney also matters in skill as well as in giving you access to the attorney-client privilege. 2. Make sure you fully understand the planning you're being recommended and that it makes sense to you. 3. Consider that your plan is a long-term asset and choose a structure which you know you can maintain for the long run. And 4, act. Get your planning in place, get it funded, and get it aging. The longer it's in place, the stronger it will be, and the sooner you'll benefit from the peace of mind that comes with good planning. Remember, it's your money. Act like it.